to type things in. All right. So, welcome everyone to Piggy Bank Essentials with Martin. This is our quarterly program, and I'm Vince King. I'll be your host today. I'm so glad you could join us. Now, before we jump in, let's talk about we ask everyone to observe the following meeting agreements so everyone can have a good experience. Please keep yourself on mute. Let's not have any distracting background noises. Use the chat to raise questions, add comments. Assume everyone's good intentions using respectful language and tone. Now, please note, if your camera is on, we can see what's happening in your background. So please don't bring your camera into the bathroom with you. Now, this meeting is being recorded, so those who can't be with us today can still view the program at a later time on our AARP California YouTube channel. Now, I think you probably heard the little message, and please click Got It when it's on your screen. If you're not familiar, AARP is the nation's largest nonprofit, nonpartisan organization dedicated to empowering people to choose how they live as they age. AARP works to strengthen communities and advocates for what matters most, with a focus on health security, financial resilience, and social connection. Today's program focuses on financial security, which is a part of our social change agenda. If you haven't already, please put your first name and what city you're zooming in from in the chat. Jacqueline, who's in the audience today? What do you see in the chat?
Oh, we have a lot of people from all across the nation today. We have Rose from Bellevue, Washington. We have Delano from LA. We have Robert from Atlanta. We have Doug from Monrovia, Maryland. We have Cheryl from Philadelphia. We have Ralph from Orange County, Nancy from Petaluma, and we have Lynn from Tampa. We have a cross section of everybody for this great program today.
Yeah, I guess it's a very popular topic. Thank you, Jacqueline, and thank everyone for joining us today. It's good to see you. Now, to get warmed up today, we have 2 poll questions, and I ask you to quickly submit your answers. They should be coming up on the screen now. Poll number 1, do you currently have any estate planning documents prepared on your behalf? So if you did it yourself or somebody else did it for you, do you have estate planning documents? Wow, looks like a lot of people don't. So I guess today's topic will be very helpful and useful to all of you. Great. Second poll should be coming up soon. Poll question 2, have you discussed your estate plan with any of your loved ones? All right, so it looks like more people have done this, but you just haven't done your documents yet. So today's session will be very helpful, I think, to get started with all of that stuff. All right, today is the 3rd of our four-part quarterly series, Piggy Bank Essentials with Martin. Each quarter this year, we will focus on a different aspect of money management. And today, we're excited to bring you the basics of estate planning. Now, we do want to share our disclaimer. This session is intended to be informational and educational and does not constitute financial advice. Please consult your financial or tax advisor or lawyer for advice regarding your personal situation. AARP is not responsible for the consequences of any decisions or actions taken in reliance upon or as a result of the information provided during this event. All right, so now it's my pleasure to introduce our guest speakers, Martin Booker and Tanae Smith. Martin Booker is a program manager at AARP, leading various financial education initiatives about investing, Social Security, and budgeting. Martin has a master's degree in social work from the University of Connecticut and is a certified financial planner. Prior to coming to AARP, he worked in the nonprofit sector in Washington, D.C., and developed a passion for helping people improve their money habits. Today, Martin offers individual and group coaching services and classes and leads workshops about credit, investing, retirement planning, and other finance-related topics. His goal is to engage and educate people to better understand how to make money and keep their money. A Baltimore, Maryland native, Tanae L. Smith, received her bachelor's degree and went on to obtain her Juris Doctor from the University of Baltimore School of Law in 2015. From 2008 to 2016, Tanae worked at a law firm in Towson, Maryland, where she was promoted from a proofreader to a paralegal to a law clerk. Then she became a Maryland licensed attorney in December 2016 and began practicing estate planning and other legal assistance at Senior Legal Services, a nonprofit organization of the Bar Association of Baltimore City and the Baltimore Bar Foundation, Inc. Today, Ms. Smith works as a regulatory counsel for the FDA and in addition to running her own practice, the TLS Law Firm. And here's a few fun facts from our speaker, Ms. Smith. Purple is her favorite color, and purple happens to be the color of elder abuse awareness. Financial exploitation is the #1 reported elder abuse crime, which is important when we discuss the financial power of attorney today. She has 3 kids. Her oldest son is 17, her daughter will be 9, and her youngest son will be 6 this year. And here's a legal fact from Tanae. If you have an estranged spouse, you cannot just simply leave him or her out of your will. They have a right to a certain amount of your estate. So your estate planning attorney should recommend that you get a divorce before finalizing your will. And remember, please put any questions for Martin and Tanae in the chat during the program, and they will answer them during the Q&A portion. So welcome, Martin and Tanae.
Thank you, Vince. So excited to be here today. All right, so we're going to dive in. I want to make sure that we get all of this information covered. It's such important information, and we know how dense estate planning can be. So what we're going to do is today you're having Piggy Bank Essentials with Tanae. She's going to walk you through all that she can about estate planning, and instead of it being an interview, she's just going to kind of dive in. Now, I want to make one thing clear before we get started. We will be talking about the basics. So we're talking fairly broadly about estate planning. We're going to have a more in-depth conversation for California later this year with a California estate planning lawyer who can give you more basics on California law. But today we want to just make sure that we know everything we can about estate planning, because it is important to make sure that we all get started in the right way. So with that in mind, let's pass it over to Tanae. Thank you for coming today. She'll get started with her presentation, and then she'll answer all your Q&A questions. So feel free to fill up the chat with your questions, and we will answer them at the end. So Tanae, you take it away.
All right. Can you see my screen?
Not yet.
All right, let's try again. Share.
Perfect. All right, we see it now.
All right, let me get it. So welcome. Thank you for having me to this morning or afternoon, depending on where you are. I am Tanae L. Smith, Esquire. As stated before, I'm only licensed in the state of Maryland. Today's presentation will provide a general overview of the different estate planning documents and why you need them. Again, disclaimer, today's presentation is for educational and general purposes only and is not intended to be legal advice and does not create an attorney-client relationship. So why do you need an estate plan? It consists of the last will and testament, often referred to as your will. You'll hear advanced medical directive and living will. I'll talk about your financial power of attorney. And then I'll hopefully provide you with some other considerations and some other documents that you should have in your estate plan, that you may have in your estate plan. Next slide, there we go. Benjamin Franklin once said, if you fail to plan, you're planning to fail. According to CNBC, approximately only 30% of Americans have an estate plan. In other words, 67% of Americans do not have an estate plan. And today the poll showed about 42% of you guys do not have an estate plan. I don't like to fail. And since you are here today, I'm sure you don't like to fail either. So why do you need an estate plan? It's not just for you, it's for everyone, high income, low income, little wealth, or very wealthy. Again, the basic 3 documents are the will, the advanced medical directive, and power of attorney. You are providing for your loved ones upon your passing, and you designate where you want your estate to go, and it's not based on what the state law says. In the medical directive, you relieve your loved ones from making making medical decisions. And in the power of attorney, you designate someone to handle your financial affairs. It provides peace of mind. That is the next slide. Provides peace of mind. You can appoint someone you trust to handle your estate. And in Maryland, we call that the personal representative. Other states, you're going to hear executor or executrix. With these documents in place, you can prevent court delays, guardianship, and family disputes. Having an estate plan, again, gives you and your loved ones a peace of mind. Let's talk about the last will and testament. Now, it only takes effect after your death. And I know it's an obvious statement, but I wanted to point it out because the power of attorney and the advanced medical directive are no longer effective when you die. The person who makes the will is called the testator, that's the male, or testatrix, that's the female. When you die, you are called the decedent. The person in charge of your estate is your personal representative, or again, your executor or your executrix. These are several sections that begin to formulate your will. Burial versus cremation, you should know, you and your family should know what your wishes are well before the will is even admitted to probate, because that is going to be taken care of well before anyone looks at your will. Real property, most people would include their own primary residence and the property or any other real property they own. Residuary estate is everything that is left over after the distribution of personal property, real property, fees, claims, and taxes or other legacies. For instance, a specific distribution, you could leave a gift of $100 to a beneficiary. That would be distributed first before the residuary estate. If you're planning to leave an inheritance, usually money, to a minor child, the Uniform Transfer to Minors Act, or UTMA, is in most states. And if anyone under the age of 21 inherits under your will, your personal representative has to appoint a custodian to hold the assets, such as in a bank account, where the assets will remain until the beneficiary is 21. All states have enacted UTMA except for South Carolina. The next section for minor children would be to appoint a guardian. Think about who will take care of them after both parents have passed away. In your will, you appoint your personal representative or your executor or your executrix. I will discuss some qualities of a personal representative shortly. Other things you should consider when creating your will include your marriage. No matter what you put in your will, if your estranged spouse wants to contest your estate and elect his or her rights to his or her share, he or she can do that. The best thing for you to do is to have a finalized divorce so that spouse cannot inherit. Probate is a legal process whereby the orphans court or register of wills wraps up your affairs after you die. Your will tells the court and your personal representative what to do during the legal process. In Maryland, the will is not required to be notarized, but when my clients have out-of-state property, I do recommend for it to be notarized. Please check your state requirements. So what can go in your will? Heirlooms and personal property do not have a beneficiary designation. So this section is probably very crucial for people who want to leave jewelry, for instance, to a beneficiary. Generally, if something has a beneficiary designation or the jointly titled property, that does not go in your will. Those assets operate outside of probate and the court has no jurisdiction over it. I like to place my client's car in their will as a backup plan. In Maryland, we do have a transfer upon death form for your car. The will can include more general language, such as any car I may own upon my death, because the transfer upon death form does not account for the car being totaled, stolen, or sold during your life. The will does, if you wish, simply direct any car you have to go to that specific beneficiary. So the basic requirements in Maryland is that the personal representative be at least 20 years old and live in Maryland. So I can imagine that some states do require that the personal representative be a resident of that state. You will see the qualities of a personal representative. Again, they're across the board: trustworthy, honest, organized, good with money. And it does not have to be your family member. It just has to be someone that you trust. It can be your best friend. Some of the general duties and responsibilities of a personal representative include, but are not limited to, taking your will to the probate court or retrieving it from the probate court if that is the place where you have kept it for safekeeping. They pay for the fees of publication, paying taxes and claims, making sure beneficiaries receive their inheritance. They can transfer a house or sell a house, file forms and other reports required by the court. The personal representative can also hire attorneys and advisors to assist them in the probate process. Now, some of you may think, I don't have any money, so I don't need a will. The question is, what if you or your estate get some? What if you inherit some money? Where would it go? Unfortunately, if you imagine the worst case scenarios that I have listed here, car accidents or wrongful death, your estate would be entitled to that money. So your will would designate where that money goes. When I think of the lottery, I think that if you die before you receive the payout, again, where would that money go? If you do not have a plan, this money would be handled by your estate. Can you just drop in the chat real quick, like how many of you know someone that plays the lottery, or if you play the lottery yourself? Jacqueline, can you let me know if you see a lot of yeses or nos?
Oh, a lot of yeses.
So please think about your will.
A lot of yeses.
Or if it's not you, at least have your friends think about their will and where would that money go. Next slide. So I have talked about what goes into your estate. Let's talk about what comes out. Probate fees can include a fee for a small estate. In Maryland, a small estate is less than $50,000. A regular estate is above $50,000. There's a nominal bond, there's a publication fee, a lien certificate if you have a property, and recordation fees if you have real property. And if your PR does not have a death certificate, again, that's another fee. A nominal bond is waived for your personal representative. If you just create your will, you can avoid that cost if you write it in your will. Estate taxes depend on the value of your estate. The inheritance tax in Maryland is 10% on any value over $1,000. State inheritance taxes vary by state, and some states do not have an inheritance tax at all. Inheritance taxes do not apply to children. Usually it applies to nieces and nephews. Creditors' claims can include attorney's fees for administering the estate, to say that 10 times fast. It's not just your credit cards or other things you owe. And again, the net estate is the residuary estate after all these things have been paid. So if you don't create your will, your state has made one for you. When you pass without a will, it is called intestate. and it will go by the laws of intestacy. You need to appoint a PR because why would you want your creditor's attorney to handle your affairs? They are looking out for their payout and they're looking out for themselves and not your loved ones. Think about how much money you want to leave to your children, loved ones, or other family members. Here, I want to point out Maryland's new law, effective October 1st, is disregarding adult children if you're married. So again, the surviving spouse receives 100% of the estate. And I can see that becoming problematic, and I can see more people wanting to create their will. And again, if you have that estranged spouse, don't forget to finalize your divorce so they don't inherit 100% of your estate. Lastly, just think about the general benefits of creating your own will. You decide what to do, not the state. You may avoid family disputes, and you can allow your family time to grieve. If you change your mind at any time, you can revoke your will. Next, we'll talk about the Advanced Medical Directive and Living Will. It's a two-part document in Maryland. The first half of the document appoints your medical agent, also known as your healthcare proxy. No matter what your state calls the document, make sure you're appointing your healthcare proxy or your healthcare agent. That's the person that's going to talk on your behalf when you're unable to. The second half of the document is the living will, where you designate your actual medical wishes that your agent should follow. This document assists you, your loved ones, and the doctors when you are unable to speak for yourself. But as long as you can express your wishes, the doctors will still listen to you. The healthcare agent must be at least 18 years old. And they have many powers, including but not limited to the power to decide where you are treated or even to ride in the ambulance with you. Your agent is not responsible for your medical costs. I will repeat that again. Your agent does not pay your medical bills. And please advise them not to sign anything that would make them responsible for your medical costs. When choosing your healthcare agent, you want to think about their qualities. Are they loving and caring? Do they know you and your wishes? Do you have the same values? Maybe you both believe in life-sustaining measures. A medical background is not required, but it may be helpful. And that person, again, has to be trustworthy and honest. HIPAA is authorized, meaning your doctor can discuss your medical information with your agent and vice versa. Your agent will have access to your medical records. The HIPAA authorization can be made effective immediately as soon as you sign the document, or made springing, meaning your agent does not have access to your medical records until you are incapacitated. Making a document springing can cause some delay in the decision-making process because you need your doctors to certify your incapacity. Your statement of goals and values is included in Maryland's Living Will. I had a client simply put that she wished to die at home. That was very important to her. So ideally, her agent should try to follow that goal and value. The next section is you have to think about what do you want when there is no chance or hope of your recovery and death is imminent. You get three options. You can allow natural death to occur with no medical interventions and no feeding tube. Or you can allow natural death to occur, but I like to say, I don't want to starve to death, so still give me a feeding tube and still give me nutrition. And the third is extend my life as long as possible. I want all the medical interventions. There are three circumstances outlined in the living will where death is imminent. There's a terminal condition, a persistent vegetative state, or end-stage condition. In all three circumstances, you have the same three options previously mentioned. Excuse me. If you have a question about any one of these circumstances, please ask them in the chat so that I can give you a more specific definition. Your preferences can be a guide for your healthcare agent, and you can give the agent the power to have the final decision, or your preferences can be strictly follow exactly as you have written, even if your agent believes another alternative is better. Excuse me for a second. We mentioned some of the helpful qualities earlier. Your preferences, again, can be a guide for your agent, and your agent can have the final decision, or they can be followed exactly as written. The same slide twice. It can be revoked at any time, and it must be accepted by healthcare providers throughout the state. This is in Maryland. If you have a valid living will and advanced medical directive, it must be accepted. It's signed by 2 witnesses and does not have to be notarized. Again, you'll have to check your state's requirements. So if you do not have an advanced medical directive, your state has one for you. I want to point out, so here I have listed the priority of the medical agents that are listed in the law. I want to point out the importance of naming one agent at a time in your documents. If you do not have this document, the state and the state decides that 2 or more adult children have the right to make your medical decisions, and they cannot come to a unanimous decision. The Patient Care Advisory Committee at the hospital ultimately gets involved. A committee will make your final healthcare decisions, not your agent and not your loved one. The committee does not know you or your wishes, so why not have the advanced medical directive? Think about the benefits of creating your own advanced medical directive, as I discussed. It eases the burden by letting your family know what you want. And they should be thinking about how to take care of you and spending time with you. If you let them know exactly what you want in writing, it's already there. Next, we're going to talk about your finances, your financial power of attorney. The power of attorney is the most powerful document in the plan, and is the only one that's required to be notarized in Maryland. The financial power of attorney is also known as personal financial power of attorney or durable power of attorney. You are called the principal, and your agent is the person you are given the power to. It's simply called the agent. Your agent stands in your shoes and can do anything that you can do. They simply present the power of attorney to the bank or to the third party. It does have great potential for abuse because the agent has access to everything that you own, but you should be naming someone you trust to handle your affairs anyway, and they should not even be thinking about stealing from you. The power of attorney can be made effective immediately as soon as you sign the document. The agent has all the power and authority, or it can be made springing, meaning it's only effective after doctors have certified you are incompetent, and the details for that can be very specific. It can also cause some delay because you need a specific written statement from a doctor or a licensed psychologist. Excuse me. What makes a good agent? Compare the qualities of a good agent versus not so good agent. You want someone with integrity who is organized and responsible with money. Again, it does not have to be a family member, just someone you trust. Think about it. If the potential agent cannot handle his or her own affairs, how are they going to handle your affairs? After appointing your agents, your power of attorney states the powers of general authority. Your agent has general authority included, but not limited to, what I call the power to hire and fire. They can hire and fire attorneys, advisors, accountants, or other third parties. Your agent can go to court for you or represent you before a government agency. And a catch-all provision is the agent can do anything lawful with respect to the subject and properties that are listed in the power of attorney. So what are those subjects and powers? They have power over all of these things listed in your power of attorney. It must be specifically enumerated under the subjects and authority section. One of the things they could do, for instance, is they have the authority to refinance or sell your home. I can provide other examples of the other subjects. If you have a question, please put it in the chat. Again, your power of attorney needs to be really specific, and all the powers have to be specifically listed. In Maryland, we have a special instructions section. And in the special instructions section, we usually talk about Medicaid planning. I heard that you guys will have a separate presentation on Medicaid planning, so I just wanted to point out the power to participate in Medicaid planning strategies must be specifically listed in the power of attorney. This is important because when you're applying for Medicaid, you know you have to have low income and low assets, and everything is limited. How many of you guys have heard of Medicaid planning? Jacqueline, can you check the chat? And I wouldn't be me if I didn't talk about Medicaid planning for a second. That's where my background started.
No, we have some answers, some no. They haven't heard of Medicaid planning.
Okay, so hopefully
That's a really good topic, yeah.
that's the next hot topic for you guys. Besides the general power of attorney, you can have a limited power of attorney. If you don't want your agent to have all access to everything you own, you can specify they have authority for a specific single transaction or for a limited period of time, such as while you're on vacation, or maybe you just need a little bit help selling your house. Maybe you just need a little bit of help buying your car. Although you should be naming a person you fully trust, the limited power of attorney has less potential for abuse by the agent because the agent can only act with that one single thing or within one period of time. In your power of attorney, you nominate your guardian. It prevents guardianship. A guardianship can also be known as living probate or conservatorship in other states. Someone has seen that you are no longer able to care for yourself, either physically or financially. Excuse me. You are losing or have lost some type of capacity. So someone petitions to court where the court can find that you're legally incapacitated. The result is the court appointing someone to have control over your medical and or financial decisions. This could be someone you do not know, they do not know you, and they do not know your wishes. So why not just go ahead and nominate that person in your power of attorney? When you have multiple agents, make sure everyone is on the same page and has each other's contact information. And here's a state example of a power of attorney. You will go through the guardianship process. This is not a list of all the possible agents, but you can imagine if you don't have anyone to step up for you, an attorney could be your agent that the court appoints, or someone agent at a health department or social services could be your agent. Adult children and a spouse do have priority over the health department or attorney, but the court will take a closer look at them and could disqualify them for any reason, such as a criminal background. So again, why have your loved ones go through that court process when you simply could just name them in your document? Maryland currently follows the Uniform Power of Attorney Act of 2006. And the Maryland Power of Attorney law is now changing effective October 1st. And I actually have to take a class myself next month. Coming to the home stretch. I'm surprised I made it in 30 minutes. Other considerations. You want to consider the various types of trusts. There are, you may have heard of revocable trusts, irrevocable trusts. There are Medicaid trusts, There are special needs trusts if you're taking care of a disabled child or anyone that has public benefits and you would like them to inherit, you should create a special needs trust for them. There are deeds. You can have a life estate deed with or without powers. Again, with the Medicaid planning, I typically recommend the life estate deed without powers. You remain the owner of your home, but you appoint a beneficiary, your remainderman, to receive your house when you pass away. But business succession planning, if you own your own business, that can be a whole nother set of documents outside of your estate planning documents, but you want to make sure everything lines up. Consult with financial advisors, accountants, and attorneys who practice estate planning. And estate planning attorneys may have some additional specialties such as the business or elder law Medicaid planning attorneys. Those attorneys, so many elder law attorneys are estate planning attorneys, but not every estate planning attorney is an elder law attorney, if that makes sense. And I heard there may be some questions about trust. So this is just an image of what goes into a trust and what goes into a will. Basically, protecting the fees, avoiding probate fees, avoiding guardianship, and a probate court is a public process. So anyone that wants to know your business, unfortunately, can look up your name, your date of death, and find out what's going on in your estate if they're willing to pay the court fees for copies of documents or something like that. All right, Jacqueline, that is all I have. I am over to you.
Okay, we have a ton of questions.
I'm sure.
And some of them will require more complex answers. So please forgive us if we don't get to your question. Okay, I have heard that LegalZoom will put together your family trust. My estate is very simple. I have one child. My husband has passed. Can I use LegalZoom or should I get a lawyer to put together my family trust?
That is a great question. I reviewed the benefits of doing your documents online. You have to be cautious that LegalZoom is going to have your state-specific guidelines for your trust. You may have either too little provisions or too many provisions. What I do recommend is if you want to create your document on LegalZoom, see if how much an attorney would cost to just review the document for you.
Okay. Another question, are there any conditions we should be aware of in regards to ex-spouse and estate planning, which you did touch on a little bit, whereby you could include, exclude, mention them in your estate planning when you're planning to leave your estate to your adult children?
Jacqueline, she froze.
Yeah. Give her a minute. Martin? No, you guys, bear with us for just a minute. We're having some technical difficulties. We'll get right back to you. So you probably had to go out and come back in again. So
Yeah,
let's give
I
it a
need
few
Martin
minutes.
to unmute. I mean, to show his video.
We do see all of your questions about whether or not the presentation slides will be sent out. I'm getting an answer for you right now, so we will update you as soon as we have the answer to that.
Okay, I just heard from Martin. She's coming in. We have so many people here in the presentation. I think Zoom is unfortunately logging people out. So
Mhm,
if you'll
mhm.
give us a second, she will be back shortly. We are going to give people a little extra time to get their questions answered. So we are waiting for her to come back.
Letitia, will we be sharing the presentation slides with everybody?
I have to get clarification from her because this presentation is being shown all over the United States. She may not want her slides to be shown because she is in Maryland and different laws pertain to different states.
Got it.
And we will be having a more in-depth presentation in October discussing things that take place in California because our laws are a little bit different. Just
Is Martin?
also, Martin just informed me that he was dropped as well. Okay, so he's coming back in. If you can make he and Tanae co-host, that would be great. Tanae's coming back in. Perfect. Martin, you're muted. Can we make Martin a co-host?
Looks like he was dropped again. Well, sorry, everybody. This is the problem with having such a popular channel is that everybody's here and our speakers can't get back on.
If people could stop their video, that might reduce some of the traffic.
Okay. Tanae is back and she should be available as co-host. Tanae, are you back?
Can you hear me? I'm back. My background's a little
Yes.
different. I had to switch computers.
Yeah, definitely. You ready?
Yes, I'm ready.
Okay. We'll repeat the question I asked. Are there any conditions we should be aware of in regards to ex-spouses and estate planning whereby you would include, exclude, mention them in your estate planning when you are planning to leave your estate to your adult children?
If you are planning to leave your estate to the adult children, you have an ex-spouse. If they already exed out, if you already have the divorce, don't even mention it. Don't bring them back up. That's the condition. Don't, if you already divorced, no need to mention them again.
Okay. I have a question. I want to remove a relative from my document and replace her with another relative to leave him money. What is the easiest and least expensive way to do this?
To leave someone money. So when first I thought it was an agent. So I want to clarify the question. Are they talking about a will or a power of attorney or a medical director?
From my document, it just says,
My
so I'm
document.
assuming.
So
yeah.
I'm gonna try to cover all three real quick. In a will, you can revoke your will at any time. So the least expensive way, if I don't recommend this, you could try to like rewrite what you already have printed out, but I don't recommend that. You would have to go who prepared the document, go back to that person to see if they will charge you less for just simply switching out a name. I honestly, in my practice, I do that for small changes to the same document. If it's a power of attorney or a medical directive, you need to alert the bank. You need to alert the bank, I'm changing my power of attorney, and go ahead and create a new power of attorney. Power of attorney and medical directives can be available on some state websites, but again, you have to be careful that any provisions that you want are covered in those documents. that's why attorneys get involved.
I'm single with just 2 siblings and 1 nephew. Do I need a trust or will a simple will do? I don't own a house or any real estate, just investments. I have prepared my advanced healthcare directive, but since my parent is now older, should I update it to name my siblings?
Yes, if you're you can still keep your parent on your documents and have your siblings as the backup plan. You can always name a primary agent or a primary personal representative and then a secondary person. I do not, it sounds you don't have a house. It doesn't sound like you have a lot of assets, so I do not recommend a trust because you're going to pay a lot of fee up front. I hear echo. A trust is way more expensive up front than a will. A will is more simple. And then for your investments, Martin can correct me if I'm wrong, if he was able to join in. On some of your investments, you should be able to designate beneficiaries. So again, you can designate your nephews or your siblings.
I'm the executrix of my mother's living trust and will. I reside in California. I only have signed copies of the documents and would like to know if those are acceptable when my mother passes. The attorney who prepared the documents closed his practice and he is nowhere to be found.
Because you're in California, I can't speak specifically to what California can do, but thankfully you do have documents. So get the process started. Go ahead and admit it to the probate court and let the court know the situation. Let the court know you don't have originals because the attorney has closed his practice. Let the court decide whether they will accept the copies or not. And hopefully they will accept the copy so that it can go by your mother's wishes. That's a good question. All good questions, actually.
A lot of them too. Only almost 70, no problem. If your home is only in your spouse's name, does it go through probate and are there additional taxes or fees applied?
No, if it's only, if you have a jointly titled property, the house, usually a husband and wife own a deed together. Once you pass away, it goes to the other spouse. No probate fees, it's automatic.
Okay. I keep money in the bank and we have added her name to account. I keep money in bank and we have added her name to the account so she can do whatever with the monies as she may see fit. I don't really know who they're referring to. Okay. Oh, here off YouTube. What is the difference between a will and a living trust? Which of the two is better? Should a person have both of them?
When you create a trust, you're always going to have what's called a pour-over will because the pour-over will is a catch-all provision. A living trust is effective while you're alive, but the trust is becoming the owner of your assets. It prevents probate fees. It prevents taxes if you're dealing with the IRS, estate taxes. When I think about trust, I think about millionaire clients, honestly, or $500,000. So if you think about, when you think about the trust, think about what you're going to put into the trust. And if you're what you're trying to avoid, how much are the fees you're trying to avoid, probate fees and taxes.
Okay, you've kind of answered this one, but for real estate, to avoid probate court, is it better to have your property in a revocable trust or irrevocable trust? What are the pros and cons of both?
For real estate court, so to avoid real estate court, if you want to, or avoid probate court, that's the way to phrase that one. You do want to trust if that's the ultimate goal is to avoid court. If it's a revocable trust, you still have access to the home. You still have some rights under the trust. Irrevocable it sounds like just how it is, irrevocable. You cannot revoke what you just now put into your trust. So that's one of the benefits. I typically do not currently prepare revocable and irrevocable trust. I saw a question.
Could you please-
Can I
could you
answer
please-
this question?
Could you
That's-
please
Go ahead.
clarify the difference between a power of attorney and a guardian?
A guardian is the official name for when a person is appointed by the court. The power, and that person has went to the court to obtain guardianship over you and your affairs. The power of attorney is the document that you created to give the agent the power so that they don't have to go through the guardianship process. You can nominate your guardian in the power of attorney just in case someone else is trying to contest the agent's rights and responsibilities. But the appointment of a guardian is in the power of attorney, and your power of attorney names your agent.
Here's a question. How to specify conditional preference? If I am under 80, use everything to keep me alive. Over 80, conditional measures such as palliative care, end-stage condition, natural death, etc.
They want to know how to specify that.
Right, how to break it down into, if I'm under 80, do this. If I'm over 80, do this.
Put it in your living will very specifically.
Okay.
You may have, depending on the state that person's in, the attorney might have some special language, or that state might have special instructions to put in the living will.
Oh, here's a good one. Okay. What happens from YouTube? What happens if the person who has power of attorney dies? Should there be more than one?
Yes, in my power of attorney, I do recommend a first primary agent and a secondary backup agent. And there's even space for a third backup, another backup agent. So you can list as many as 1, 2, 3 in your document. Some states may have more. But what would happen if you don't have one? Depending on the assets involved, again, that guardianship process may come into place. If you physically or mentally can express who you want to take over.
How do you determine if you need a will versus a trust if you have just one child and he is joint owner in the house and car?
If he's already joint owner, you probably just need a simple will as a catch-all provision. Again, if anything, if you should inherit any money, Lord forbid, if anything bad would happen to you where you could possibly inherit something, your son would get all of the benefits in your will. So you need a simple will. Keep him as the beneficiary on your house, or if he's jointly titled on your house, that's great. If he's jointly titled on the car, that's great. They will operate outside of probate.
Sometimes, a question from YouTube, sometimes in the hospital, they have you sign a lot of papers, and sometimes they won't treat a person until someone accepts someone to be responsible to pay. So as a chosen agent, what should you do?
The person being admitted to the hospital is still responsible for their own healthcare costs. Then it comes down to emergency rooms. If the person doesn't have health insurance, usually they're not rejected from the emergency room. However, if you know you're going into a procedure and you need health insurance in advance, then the agent should work with the principal, work with the person then in the document, work with that person to try to obtain health insurance, but don't sign anything that would make you personally liable for the financial costs.
Okay, and so last question. And
To keep it
There's
going,
a will-
Jacqueline, till about, we're gonna keep it going till about 10:15.
oh, okay, for sure, okay. Does a will have to be filed in the court once prepared?
No, once prepared, you can keep it yourself. If you have a fireproof safe in your home, you can keep it there. it's not filed with the court, it doesn't become public record until you pass away. But the court also has their own fireproof safes. And like here in Maryland, you can leave it for safekeeping for like $5.
Okay. If you designate beneficiaries for your financial investments, do they have to pay inheritance taxes on what they receive?
Ooh, that's a good question. Is Martin back on? I do need him for that one.
Yeah, I was
Yeah,
thinking,
wait,
Mark.
yeah, can you repeat the question, please?
If you designate beneficiaries for your financial investments, do they have to pay inheritance taxes on what they receive?
When they so it's possible there are estate taxes that are typically paid. One of the only investments one of the only things that's typically passed down completely tax free is going to be life insurance policies.
Okay. I have a daughter with mental health challenges. Can I leave her inheritance in a trust?
I saw that question. That's a good question. You can leave her inheritance in a trust, and it's probably highly recommended that you do a special needs trust if you foresee that her mental health challenges are going to cause her to be on public benefits in the future.
Okay. We have a question. Can you please repeat power of attorney versus guardian, the definition or the clarification?
Okay. So the power of attorney is the document. And in the power of attorney, you appoint an agent. The agent can act on your behalf for all of your financial affairs. And a guardian is appointed by the court. It may or may not be the person named in your power of attorney. The guardian will have access to your affairs, probably medical and financial decisions, and even physical if you can't take care of yourself. So the guardian is, think about guardian and guardianship appointed by the court. When you think of power of attorney, think of you made it yourself. You are giving this person the power.
Can two people be named the primary power of attorney, or does one have to be primary and the other secondary?
Because of potential family conflicts, we usually recommend that you don't name two people at once. You can, but it's not recommended. So I have seen in the past where brother and sister are named to act jointly or individually. So they can either act together or they can either act one by themselves. The problem is some banks or third parties and institutions may require both parties to be together, despite what your document says. One may, Lord forbid, one may be doing their own thing and not following your wishes. So we do recommend one at a time.
Okay. This is a good one. Do you need to change your documents if the female changes their last name due to marriage or divorce?
Oh, that's a good question.
Mm-hmm.
I do recommend that you change your documents due to marriage or divorce if you change your name. It's not urgent, but it is definitely something on your to-do list. If you don't do it right away, make sure you have that backup document that change your name, that court order that changes your name.
Okay. This one I'm gonna look, but if you name more than one power of attorney for finances, do it jointly and not in severability. This person had a bad experience with that. Can you speak to that a little bit?
Can you repeat the question? So
if you name more than one power of attorney for finances, do it jointly and not in severability. I had a bad experience in severability.
Oh, she just stating a comment. So she's recommending that they do it jointly. So she's requiring both people to act jointly. So do not do jointly and or individually. She wants that person to do it jointly. Attorneys can write it like that. If you can require two people to act together, but remember, they must act together. Can those two people cooperate and be with each other every single time you need them to make transactions and decisions.
Okay. What should I do if the law office that drafted my trust closes?
Are you trying to make changes to the trust now? I'm assuming. It's okay if the trust is already created and it's well written and you don't have any changes, you should be fine. But if you're trying to make changes, you would have to seek a new attorney, new legal advice, and take your old documents with you.
A question that comes up has come up several times for different states. Can you give us some insight as to a good way to find an attorney to do your trust in the various states?
Atisha alerted me of that a couple weeks ago. Every state has a bar association, so the attorneys are members of these bar associations. I would Google like Maryland State Bar Association, and there are different sections. We have an estate planning section, we have an elder law section, or elder law council, estate planning council. You should be able to find attorneys that way. They have hotlines you can call and get recommendations from.
Okay. Someone said that they heard that a will may not be enforceable without a trust.
That's not true. A will that's not true. That's completely false. Because there are many, many people that will create a will and don't have a trust or don't need a trust.
Okay. If you are named as having 50% inheritance in a will, if you do not want to participate or take the inheritance, can you remove or disqualify yourself from the inheritance?
Ooh, that's a good question.
Mm-hmm.
Why? You can, but I don't know what the probate court, you would have to let the probate court know that you do not want your inheritance. What happens is it will go to the residuary estate, and whoever's named as the residuary, if you named as the 50% and you're named as the residuary, I don't know how you would, how the court, I guess the other person, the other half would get 100% versus the 50. Like the court would decide.
Okay. Why?
Atisha told me to say everything must be signed, and you must sign it in the presence of your witness and your notary if required. Do not sign your document and then take it to your witness. You can't do that.
No.
Everybody has to be, they actually in olden days called it like a signing ceremony. Everyone's there together to sign, to watch you sign, the witnesses sign, and the witnesses actually sign and provide their address. And again, if it's a document that needs to be notarized, the notary has to be there as well.
If you have an executor in place and the executor becomes ill, dies, and has married and dies, will this default to the husband?
Not automatic. There's no law that says it automatically defaults to the husband. At least not in Maryland. So if the executor dies, if you already passed, then your executor passed. Someone has to open up your will in probate court. So the question becomes who wants to become the executor to distribute the assets in your will. It could be another beneficiary. They might want to step up and be the executor. It could be, unfortunately, a creditor that wants to step up and be the executor. The husband can, if you guys were close, if he wants to distribute the will, he can ask the court to be appointed executor, but it's not automatic default.
If my wife's name is not on the mortgage, can she sell or appoint funds for grown children when she sells the home?
I know there's a difference between a deed and a mortgage. There is a difference. I haven't bought my own home yet, but in a mortgage, a person can be on a mortgage but not be on a deed, or a person can be on a deed but not on the mortgage. So the deed is what's going to control what she can and cannot do with the house, not the actual financial mortgage document. It might be some provisions in the mortgage that won't allow you to sell or transfer the home. You need to note that as well.
All right. Does a TOD account beneficiary take precedence over an estate plan directive? Transfer on death, I think.
Yeah, transfer on death, any beneficiary designations properly written and signed off, they take precedence. They operate outside of your will.
We have children and wish to leave our assets to charitable organizations. Is it better to set up a legacy with the organization or specify specific amount if upon your death?
That's a good question. People do leave money to charity. If you simply do it in your will, attorneys may recommend that you put a provision in your will as to why you are not leaving any money to your children. Are you completely skipping your children altogether, or just going straight to the charities? If there's a way you can contact the charities and go ahead and set up specific legacies with the charities, by all means do so. If you want to avoid putting a charity in your will and avoid probate fees, you go ahead and do that.
During a conservatorship for an adult with no power of attorney or will, is it common to be forced to pay a surety bond and pay for your attorney fees and court-appointed attorney fees?
Oh, wow. Some of that sounds excessive, but you definitely do have, unfortunately, a guardian or even executors do have to pay a bond. That's why I do recommend writing a will, and creating any of your documents avoids that person from paying a bond. You are going to pay your own attorney's fees to the extent where you can petition and ask the court for reimbursement of those attorney's fees. So if you're if you become the guardian of your mom, and your mom has assets and is wealthy, you ask the court, hey, my attorney's fees were $1,000. Can I be reimbursed for these attorney's fees? And everything in a guardianship has to be approved by the court. You can't just simply do it on your own. Can't reimburse yourself.
Yeah. Another question from you two. I currently have a revocable trust. When our children were minors, we have 2 executors of the estate. Is it best to establish a new trust or just have it updated?
I don't know why she needs to update it. She has the revocable trust. She has the executors. So she has that sounds like she has the will. Executors are in a will. The trustees are of the trust. So if you have 2 trustees, you have 2 executors in your will. Unless you need to change a provision, I don't see any reason you need to update that, if that's clear.
So tag on to that, I have a question. How often should you review your trust?
I saw that. You should review when family circumstances change. If someone dies or if someone is born, you might want to leave grandchildren, great-grandchildren. And also, every attorney is different, so I said every year, and I think one of my colleagues said every 3 to 5 years. So somewhere in life changes in circumstances, and every year to 3 to 5. Like the Power of Attorney Act is changing in Maryland, and that's already 20 years. The Power of Attorney Act is like 13 years old. So yeah, that's definitely overdue for a review.
Can you please clarify again a response regarding having only one spouse on the deed or property? Does second spouse need to be added to the deed?
Oh, I thought they were already on the deed. If you want to avoid probate and you know that you want your spouse to get the house, go ahead and put them on a deed. In Maryland, adding spouses to a deed is called tenants by the entirety. That's the name for jointly titled property in a marriage. Another option is if you don't want them to own it during life, you can make them, you can do a life estate deed where they only own the property once you pass away.
My aunt passed away a few years back, and my brother is supposed to get some inheritance from her half. Later on, my uncle remarried, and he also recently passed away. How can my brother find out if there are any assets left?
Oh, wow. I'm gonna have to write this down. Can you repeat the question?
Okay. My aunt passed away a few years back, and my brother is supposed to get some inheritance from her half. Later on, my uncle remarried, and he also recently passed away. How can my brother find out if there are any assets left?
Oh, wow. So aunt should have prepared a will. We don't, that's not clear here. If the aunt prepared a will, we need to see did her will leave assets directly to your brother? And did she leave out her husband? Or did she leave assets to her husband first? And then brother was just the residuary. He was just the backup after the uncle probably spent everything else on his new wife. How you find out? He has to petition the court.
All right, so we are out of time, so we are going to close out today's meeting. There will be a part 2 of this topic in October. Martin, is that correct?
Yes, it will be.
Okay, so watch for that announcement. Meanwhile, we do want to get a survey out there so we can find out what you thought of today's program. Thank you again, Tanae, for all of your information today. We learned a lot, I think, and there's still a lot of questions out there, but unfortunately, we can't get to all of them today. So there is a link in the chat, or should be a link in the chat shortly, for you to fill out our survey to find out your feedback on today. And we do invite you to check out some other upcoming AARP events. Join us for a special Tea and Coffee Tuesdays on Tuesday, October 3rd at 9 a.m. Pacific for Medicare Basics and Enrollment. This replaces the September 12th event. And come back for our regularly scheduled Tea and Coffee Tuesdays on Tuesday, October 10th at 9 a.m. Pacific as we discuss more recycling tips with returning guest Mark Bowers. And then we will have our 4th Piggy Bank Essentials program on Thursday, October 26th at 9 a.m. Pacific. So that will be our part 2 of this topic on estate planning.